Sometimes for a startup business, it doesn't need to be an entity at all, although probably more often than not, it should be either a limited liability company or a corporation. But some types of businesses, particularly perhaps consulting businesses, may be able to just operate as a sole proprietorship. That type of business means all of the risk and all of the reward are there at the doorstep of that individual business holder. And sometimes that amount of risk is more than the individual wants to assume at the personal level. By forming an entity of one kind or another, the owner of the business, a stockholder with a corporation or a member with an LLC, can do some things to limit the personal liability and leave the liability, so to speak, at the doorstep of the entity. But with a corporation organized under the laws of the state of Michigan, it is then possible to elect tax status under the Internal Revenue Code that might allow it to be taxed at the corporate level or taxed at the shareholder level, and that's where the phrase an S corporation comes up. It's a Michigan corporation formed under the laws of the state of Michigan that then under the Internal Revenue Code, under so-called subchapter S, elects to be taxed so that all of the revenue and all of the expense of the entity of the corporation flow through onto the individual tax return of the shareholders proportionate to their quantities of shares that they own.